Good afternoon, everybody. My name is Chris Justice, and I'm here again to join you guys for another Q&A. I'm an associate, as you may know, with Samfiru Tumarkin. I work out of their Toronto offices. So I'm here today to hopefully answer, as I always try to do, as many questions as I can from everyone, all things employment law related. And before I get into some of those questions, while they come in, I usually start off with a couple topics or general pieces of advice going forward. And this week, I want to talk about a couple of things that are more topical within the news, having to do with the COVID pandemic that's, of course, ongoing, and as well having to do with the issue of resignations and what constitutes a resignation. So, having said that, I'll start with the COVID related stuff. And this actually has to do with the mask mandates as far as them being lifted in Ontario as of today. So, as many of you know, there's no longer a mandate in general when it comes to wearing masks, although there are still some restrictions in terms of masks in certain areas, such as public transit, long-term care homes, healthcare, and shelter settings. And I understand that the mandates that relate to those particular areas will be lifted at the end of next month, that being April. But as far as the mandatory mask requirements more generally are concerned, in terms of workplaces, offices, and those types of settings, restaurants, bars, etc., they are being lifted today. So, having said that, I'm sure a lot of you will have questions as far as whether or not your employer may still require you to wear a mask, and what ramifications or consequences would there be if, for example, you were not willing to wear a mask beyond today's date after these mandates had lifted. So, first of all, can your employer mandate or require you to wear a mask even after the mandates from the provincial side of things have ended? And the answer to that, generally speaking, is yes, they can. Now, if you were to refuse wearing a mask, there may be a risk that your severance entitlements could be affected. But as we see the COVID numbers start to decrease, and as the world returns to a greater sense of normalcy, it's going to be much more difficult for employers to demand that you wear a mask. And if you don't, try to terminate your employment without any severance whatsoever. Right now, obviously, the numbers are going down. And it's a bit unknown as far as whether or not a company would actually get away with terminating someone for just cause right now due to mask requirements. But there is generally an ability for them to keep you wearing the mask. And of course, that's for safety related reasons. Now, if you're somebody who can't wear a mask for some medical related reason, then certainly your employer still, as it always has had to, your employer still has to accommodate you. So this requirement doesn't apply to everyone, generally speaking. And if your employer forces you to wear a mask in spite of you having a medical reason not to do so, then there can definitely be a risk of a failure to accommodate, and you could very well be entitled to severance at that point. Now, I would caution those of you who are thinking about quitting in the face of a mask requirement. You definitely want to get in touch with us before you decide to quit for any reason. And you may think that quitting will result in a severance package for you down the road. But again, before you do something like that, you'll want to have a chat with our lawyers at our firms just to make sure you go about doing it the right way. If your employer decides to take action against you for not wearing a mask, then again, that could be a separate issue. But for the most part, there is still a general expectation that masks can be required in workplaces, even though the mandate's lifted. And again, as time goes on, that's going to be more and more difficult. So definitely stay tuned for further updates from our firm in terms of this issue is concerned. But I wanted to quickly just touch on the mask issue for now. The other issue I mentioned has to do with resignations. So Some of you may know, but Good Life Fitness earlier this month had actually affected the employment, had made a decision that affected the employment of many, many employees that work for Good Life. And essentially what they did was they apparently sent out a survey, and the survey was asking for the Good Life employees' response within a 10-day period. And if the employee did not respond to the survey within 10 days, they would be considered to have abandoned their employment. And so what ended up happening is many of these employees did not respond to the survey in question for a number of reasons. And 10 days later, they found themselves being told that they had essentially quit their job, and they got no severance as a result of that. And actually, a lot of people didn't respond to the surveys for reasons including they didn't actually see it. They weren't around their email or checking their systems because they were busy taking care of their elders. So there could be a whole host of reasons for why someone wouldn't have seen that survey and may not even had an opportunity to respond to it at all, full stop. So I kind of raised this story to make a general point regarding resignations, which is in order for a resignation to happen at law, it needs to be done in a clear and unequivocal way. So you as an employee have to clearly communicate to your employer that you are resigning from that job. And there has to be a mutual understanding between the two of you, you yourself and your employer, that a resignation has occurred. Far too often, what I see in my practice is, or are employers who take the position that because someone didn't respond in a certain time frame, which may be no time at all, that they have been deemed to have abandoned their job. And then essentially, like these Good Life employees, they get let go with essentially no severance. And these are people potentially with 10, 20, 30 years of service into that company. And so for companies generally to make these arbitrary deadlines for people to respond by, and then deem them to have quit if they fail to meet those deadlines, is often a very risky thing to do. Because again, you got to prove that, first of all, the deadline was reasonable, that the employee would have had an opportunity to review whatever it is you're putting in front of them, and also that you would even have as an employer the ability to deem someone to have quit if they didn't respond to a certain item. So again, it'll come down to what it is they're actually asking you to respond to. But needless to say, all these Good Life employees, I think, would be looking at potentially significant severance if, in fact, they're finding themselves in that type of a situation. And whether you're a Good Life employee or not, if you're an employee who's been in a situation where you're being asked to do something by your employer and you're being told that if you don't do it by a certain day, that you will be deemed to have quit your job, there's definitely something that happens, like I said, far too often. And so regardless of the context, you should be giving us a call, and we can take you through that process in terms of whether you have to respond, when you have to respond, and whether your employer can even essentially put your employment in jeopardy for failing to respond. Because they may make it seem like it's an urgent and a very important request, but a lot of times it's not. And these employees, these individuals find themselves then without a job, without any severance. And again, it could be a real big shame if there's someone who's put in many, many years of service, because they could be looking at upwards of 2 years of severance potentially. Having said that, as I say, those are the 2 points I wanted to kind of raise or address at the top. Now I'm happy to get into some of the questions that you guys send in. So please do send in as many questions as you can. And I'll start with Bon Lewis on YouTube, who's asking if they can use a lawyer after terminated from their union job. And this is a point I'll make for everyone. We at Samfiru Tumarkin do not specialize in unionized work. So generally speaking, when it comes to issues that you're facing as a unionized employee, that won't be something that we can help out with. 2 starting points or 2 areas that you should look to first. Number 1, always refer to your collective bargaining agreement if you're a unionized member, because that collective bargaining agreement will set out the policies and the procedures that your employer or that you as an employee with that company need to follow in the event there are any issues. So for instance, Bon, if you have been terminated, there's usually a procedure set out in your collective bargaining agreement that would detail the processes regarding termination. And aside from the collective bargaining agreement, you may also want to refer to your local union rep, because that is, of course, the person who would be representing you in terms of the union. And that would be the person, or those would be the people that would advance a particular grievance on your behalf. So, for instance, if you're looking for more severance as a result of a termination, your local union rep should be able to guide you through the process of how to do that. And until you've actually fully satisfied that unionized process, that grievance process, you're not going to be able to do much else. You got to kind of follow that process, generally speaking, through to its completion before you're going to have any further recourse at that point. So hopefully that answers your question, Bon. But I would start with those two avenues first, and then take it from there. Evelyn on Facebook is asking how much it costs to retain our office. So if you're an employee or you're an individual, whether it's an employee or you're acting, you're coming to us on behalf of an employer, we have a variety of different legal fee structures in place. So Evelyn, it will actually depend on the particular case that you have, what it is you're looking for, what it is you're asking for, what's reasonable in the circumstances, and again, just the nature of the work that you're looking for us to do. We could have a retainer based on an hourly rate. So you would pay the retainer fee of one of our lawyers in one of our offices based on his or her hourly rate. Alternatively, there could be a structure set up where the case is taken on a contingency basis, meaning the legal fees are recovered at the end and taken as a portion or a percentage of the settlement. But again, that will depend entirely on your particular matter. So you'll perhaps need to give us a call, and we can take you through the process and figure out what the best retainer option for you would be. Lena on YouTube is asking whether or not there's any precedent yet in the courts regarding vaccination policies. And Lena, as far as the non-unionized context is concerned, I'm not aware of much precedent at this point. There are some decisions that have come out in the unionized sector dealing with vaccination policies. And I am aware of some decisions that have, in that context, declared the vaccination policy to be a reasonable one, depending on which policy we're talking about. But that doesn't say a whole lot in the context of non-unionized work. And so I imagine there will be definitely some cases that get all the way to trial on these types of issues. But it may have to take place likely later on this year. So it's hard to say. But there are a number of lawsuits going on right now. So I would imagine it's only a matter of time before some of the decisions make their way to court and those decisions get released. And as soon as they get released, I'm sure at least some of us at our firm will be reaching out to the public and letting them know what the outcome is. Because it is very important, of course, from a legal perspective to have the courts weigh in on these decisions. And right now, because it is unprecedented, there is, of course, some uncertainty surrounding everything. But again, that'll be a matter of time. Having said that, though, Lena, and for all those watching, I will say that if you're in a situation where your employment has been affected as a result of a vaccine policy, you shouldn't necessarily wait for there to be a precedent or for there to be a case that comes out. You should contact us right away, because even though there is no precedent necessarily or very little, that doesn't mean that you don't potentially have a strong case and that you aren't arguably owed a lot of severance. So hopefully that answers your question. Just going on through the questions. Thanks everyone, as always, for sending them in. The Dreamer on YouTube is asking, how long does an employer have to discipline an employee for doing something wrong at work until they would have seemed to have accepted it? So I can talk a little bit about progressive discipline and work-related issues. So thanks for the question. I think this could be of benefit to many people. The answer to your question in terms of how long does an employer have to discipline an employee, it will in part come down to what it is we're actually talking about. What kind of infraction or issue are we talking about? For example, I'll bring up one sort of situation where an employee, let's say, is constantly late for work. They come in late, half an hour to an hour every single day, and their employer eventually reaches out to them and says, hey, we've got to fix this. You've got to come in on time. For something like that, you're not going to be given as much leeway as an employee to keep doing, committing that error, because it's relatively straightforward. The expectations are clear, and it's something that is, very clearly achievable in most cases. So that would be an example where you wouldn't necessarily have a long time. Other sort of the opposite to that, where you may have more time, would be something to do with your performance. So let's say, for example, that you were being criticized based on your performance by your employer. Your employer came to you, said they weren't happy with the way that you were doing the work, and they were issuing you a warning. Depending on the nature of the work, depending on how reasonable your employer's expectations are, depending on what kind of skill set you have to do what's being expected of you, there may be, in fact, a longer period of time given to you to correct those errors. And of course, this all assumes that your employer's criticisms are founded. They're actually based in some truth. Because a lot of times, companies will criticize the performance of employees, and the employee themselves will actually say, well, hold up a minute. That's not actually true. I did do this, I did do that, or this is why, you're being unrealistic or whatnot. So it's always good as an employee to object to the criticisms if they are unfounded and to put that in writing. But the dreamer, to sort of expand on the answer, there's no exact science or number in terms of how long someone has to be disciplined. It could be a few weeks. It could be several months. It just sort of depends, again, based on the nature of the situation. And if you're looking at it from the outside, the question is always, how long should it take someone to fix their errors or to correct their ways? How long would it reasonably take someone in that case to, fix all of that? So it comes down to the situation. If you're in a particular situation, and your employer is disciplining you or putting you on a series of disciplinary letters, you definitely want to get in touch with us, because it could be the case that your employer is building a case to terminate you for non-performance. And depending on how many warnings there are, and depending on how much time has passed, and also depending on the merit behind what they're saying, they could later on have a case to essentially terminate your employment for cause and not provide you with any severance whatsoever. That's a very high bar to meet. So it's not to say it's easy at all for the employer, but it's definitely something that you need to be aware of. And it's also why it's so important to push back on some of the criticisms if they are unfounded, because that's going to make it probably more difficult for your employer to then rely on later on down the road if you've objected to them earlier and you've got some clear evidence or information to support those objections. So hopefully that answers your question. But I think in terms of, yourself specifically, or if you have any further questions, feel free to give us a call or contact us online. Use our website as noted below. We've got a lot of information for all of you on a variety of issues, whether it's resignations, disciplinary issues, how much severance you're entitled to, all that kind of stuff. You can go through our website and get a lot of information there. And then if you need further information, you can give us a call and we can likely set up a consultation to discuss it further. So thank you though for your question. Just working through here. I've got a comment from Speeches Beyond on YouTube, and they are saying that they wrote to their boss late last year in September by email about being bullied and harassed by a female coworker. And they also mentioned they had a hernia, so some medical related issues. And then they advised that they were fired later on. So, and Speeches is adding that they have 5 witness statements against this particular employee who was bullying and harassing them. So thank you for your question. Thank you for your situation. It's a very, unfortunately, common situation to be in. So I think, again, this will benefit a lot of you in terms of giving an answer. But generally speaking, it seems like you did the right thing as far as emailing your boss about the bullying and the harassment. Again, it's good to put these things in writing as soon as you can. You'll want to sort of generally try to follow the company's policy as far as bullying and harassment is concerned. A lot of companies have anti-harassment policies, and in those policies will be steps in terms of how to report the issue, where to report it. So let's say, assuming you followed that process, you sent that email outlining your issues, in a lot of cases, the company will then be required to investigate. And maybe that's where these witness statements come into play. But if there is some merit behind the complaints, then there's generally that duty to do some investigation and to essentially get to the bottom of it. I don't know, speeches, if there was a finding that this person harassed or bullied you or others. So that's one thing that I usually look for in terms of whether the company agrees with you in terms of the harassment and bullying, or whether the company says that they were not able to find any harassment or bullying at play. Seems unlikely, given that you're saying there's you plus another 5 witnesses. So that would be one question, though, is did an investigation happen, and was a finding made? Did some corrective action get taken against the bullier or the harasser, if in fact they were found of doing that? And if the company satisfied that much, then of course that's one part of the process to consider. Now, you mentioned they fired you later on. So it could be the case that you were fired as a result of launching that complaint. And that would even appear to be more so the case if there was no finding of harassment or bullying made, and if there was no corrective action taken against that female coworker. So, of course, if you're someone, doesn't matter who you are, that gets terminated in response to raising a complaint that's related to the workplace, whether it's harassment, assault, again, doesn't really matter, and you then are terminated, there is a chance that you were terminated in reprisal for raising that complaint, and that can not only entitle you to severance entitlements upwards of 2 years, but also further damages for bad faith. Speeches, I don't know if you have any other reasoning or rationale as to why they fired you, if it's for an unrelated matter, even though it may be close to the time that you had presented that complaint. Because timing and everything definitely can be suspect, but there may be another reason. So I guess it would depend on what there is there. You mentioned the hernia as well. And if you're an employee who's lost their job because you believe there's some sort of medically related discrimination going on, or any discrimination for that matter, that can be a very valid concern. And again, not just entitle you to severance, but potentially human rights damages. So speeches, it looks like this may be something you want to give us a call on, and something we can flesh out a bit more, because there does seem to be a lot of issues at play. And of course, employers are never going to come out and say that they let you go for any bad faith reason. But it seems like there could potentially be a big case there. So definitely give us a shout, and hopefully I've answered your question sufficiently so far. But thanks again for raising it, because I think it's helpful that everyone knows. The Dreamer's got a follow up. So just to remind people, they were asking about how long does an employer have to discipline somebody, and what can happen after that. They say that if the employer is bringing up something you may have done wrong in the past, and time has gone, but they never said anything about it, isn't that accepting it since it wasn't brought up early? And the Dreamer, you are in a way correct. So if you're, let's say, for example, you commit some error at work, it's not a big one, but you do something wrong at work, and you do this for several months or years, and your employer just accepts it, they don't raise it, they essentially condone it, they don't really make a big deal about it. And then later on, they try to change their position and say that it is a big deal and that it is unacceptable. One of the arguments you could bring up is, well, hold on a minute. You have only brought this up for the first time now. You essentially condoned it all the other times. So I took that to mean that it either was acceptable or it wasn't that big of an issue. So that's a very valid point that you raise up. It has to do with, again, an employer condoning someone's conduct, which is something that happens quite a lot. Is there will be condonation, and later they'll change their tune, and that is a bit more of an uphill battle for them versus a scenario where it's the first time something's happened. And I think that if you're an employee in that situation, you're going to get more sympathy, and you're going to be looked at in a slightly different light than if it had never happened before. So that's just another, I suppose, piece of the puzzle in terms of the case that you may have, the dreamer. So hopefully that answers the follow-up question there. Going through some other questions. Thanks again for everyone for getting them in. There's a question from Kevin Smith on YouTube asking or saying that, sorry, not Kevin, Keith Smith, saying that he has an unemployment disability claim and he's going to arbitration. Can my case settle in arbitration? So Keith, I'm not exactly clear what it is you're referring to, but I think what you're talking about is you have sort of applied for unemployment insurance or possibly for disability benefits. And you're now at a point where there's a potential to settle this benefit claim or this employment insurance claim through arbitration. And you're asking if your case can settle in arbitration. And yes, arbitration is a general process. It's very similar to trial, where two sides essentially present their view of the case, whether you're entitled to benefits or insurance or not. And the arbitrator would be the individual who hears the decision and who makes a finding. And normally an arbitrator's finding is binding on both parties. So to answer your question, Keith, yes, if you go to an arbitration, that should settle the issues that are involved right there. But thank you for your question. I've got another question coming in from Walter on Facebook. Walter is asking, what happens if an employer terminates you without cause and after the fact says willful misconduct when a lawyer contacts them? So immediately your warning bells start to alarm. And a lawyer gets involved, the company does a 180, changes their position, and you start to think, well, did they do that because I got a lawyer involved? And now they're perhaps angry, upset, emotional about it, and trying to take some sort of retributive action against you. And if that's the case, then absolutely there's going to be bad faith there. And there's a very good chance that employer will be penalized through extraordinary damages. Especially if they terminated you without cause to begin with. Normally, the only way an employer can terminate someone without cause and then change their position after the fact is if they discover or find out something after they let you go that would amount to something considered willful misconduct. So let's say, for example, you get terminated without cause, you get a severance package offered to you, and then 2 weeks later, the company discovers that while you were working there, you had committed a bunch of fraudulent actions. And they just wouldn't have been able to find out before. So they find out later on, you commit fraud, then they come back to you and they say, forget the severance package we offered. We've got what's called after acquired cause. And then they pull the severance away and they clarify their position and say they have cause. That is one example, generally one of the only examples where an employer can sort of change their tune. But if they come after the fact and say there's willful misconduct, but they don't really explain why, or they give some reasoning that they should have known beforehand, and it just seems more like they're trying to punish you for getting a lawyer involved, then that's where you get into the previous situation I mentioned, which is, the employer essentially being in hot water and being at risk of having to pay substantially more in damages than they would have otherwise. So you want to be careful as an employer, obviously, if you're doing that, and obviously have a very good reason for doing that. But Walter, I don't know if this fully answers your questions. If it does, let me know. Let us know, get in contact, because there could definitely be some bad faith at play there, and your entitlements could be significant. I'll do one more, and I apologize to those of you that I didn't answer. I've got a question from JBK on YouTube who's asking, if put on an unpaid leave and asked to go back because of the vaccination, can I get paid? And so just so I understand the question, so you are put on an unpaid leave, possibly because you're not getting vaccinated, but then you're asked to go back because of the vaccine. I guess it would just depend on whether or not you want to get vaccinated. I will say that even though a lot of employers are requiring employees to get vaccinated under policies of their own, don't feel as though you as an employee have to get vaccinated. And don't assume that if you don't get vaccinated, you have no case, you have no ability to get severance, because the vast majority of people who are being let go for not complying with a vaccine policy are entitled to severance. And so, whether you're terminated for not getting vaccinated or you're put on an unpaid leave for not getting vaccinated, you have potential severance entitlements there that you can't throw away. So you definitely need to get in touch with our firm if any of you are in that situation, and and we can definitely take it from there before committing to going back for any reason. So JBK, I hope that answers your question, but get in touch with us if not, and we can flesh it out a bit further. And for everyone else, I will be back. We've got others at the firm doing these Q&As as well. So do try to submit your questions in at those times, and we will, as always, do our best to answer them. But for now, I'm going to let everyone go. Hopefully you have a great rest of your day, and all the best. You take care.